Welcome to Homo Politicus. You're watching Enterprise Television. It's a fine day to talk politics in the country as we go talk a major decision, a delivery, a landmark judgment by the Supreme Court that reshapes the boundaries of emergency powers in the country's democracy. In a split 6-1 decision, the Supreme Court today affirmed that President Bola Tinubu possesses the constitutional authority to declare a state of emergency in any state of the Federation where there is a breakdown of law and order or a threat of chaos and anarchy. Delivering the lead judgment, Justice Mohammed Idris held that Section 305 of the 1999 Constitution was amended and empowers the President to deploy extraordinary measures to restore normalcy once an emergency is declared. The court noted that the Constitution does not expressly define the scope of these measures, effectively granting the President wide discretion, but with limits. Crucially, the Supreme Court ruled that any suspension of elected officials under the emergency rule must be for a clearly defined and limited period, reinforcing that emergency powers are not a blank check for prolonged political control. The judgment arose from a suit filed by Adamawa State and 10 other PDP-led states challenging President Tinubu's declaration of a state of emergency in Rivers, during which elected officials, the state governor, the deputy governor, and the lawmakers were suspended for 6 months. While the court struck out the suit on grounds of jurisdiction, the court nonetheless proceeded to pronounce on the substantive issues raised. In a notable dissent, Justice Obande Ogbunya warned against what he described as a dangerous precedent, arguing that while the president may declare a state of emergency, such power should not extend to suspending democratically elected governors, deputies, or lawmakers. Today's verdicts of the Supreme Court raises fundamental questions about executive power, about constitutional safeguards, federalism, and protection of democratic mandates. Questions that go beyond Rivers State, where this happened in the month of March. And this touches the very heart of Nigeria's constitutional order. So, does this judgment strengthen national stability? Does it widen the scope for executive overreach? And where should the line truly be drawn between emergency governance and democratic preservation? That conversation begins now on Homo Politicus. Kingsley Bass is my name. I'm joined by a barrister and solicitor of the Supreme Court of Nigeria, Tunji Abdulhamid. He joins me virtually for this conversation. Tunji, many thanks for joining me today.
Yeah, Kingsley, thank you for having me. It's my pleasure to be with you.
Appreciate that. Appreciate that. Let's get straight to the conversation. I'd like to get your thoughts regarding the Supreme Court's decision on this particular one. There are fundamental questions regarding this. So from your standpoint, do you think this judgment will strengthen Nigeria's, the country's national stability? Do you think this would further widen the scope for executive overreach? And from your standpoint, where should the line truly be drawn, considering the verdict of the Supreme Court, between emergency governance and democratic preservation?
Kingsley, for me, this is a dangerous precedent. It's a precedent that will not help our democracy. It is a precedent that will give president unfettered power to do as he likes, because the governor will now be more wary and more afraid of the president. So, in other words, if anyone wants the president or the president himself want a governor to go, they will just create one crisis in that state, or some people will just create crisis in that one state, and then that will be the opportunity for them to suspend the governor. For me, Kingsley, I am sad. I won't lie to you. Today, I am sad. I do not expect to hear this kind of a judgment with due respect from the Supreme Court, the apex court for that matter. And when the Supreme Court gives decision, that means you can only appeal to Baba God, which means is a current position on ground now. So if the president decides to remove anybody the way he lies in the name of emergency, then it's good to go. He has the backing of the Supreme Court. There is no dispute as to whether or not the president has the power or discretionary power to declare state of emergency under Section 305 of the Constitution of the Federal Republic of Nigeria as amended. He has that power. The question has always been whether or not that power extends to him suspending elected office leaders or officers like governor, House of Assembly, rep, or whatever, or even the councillor. But with this issue now, the president has unfettered power to remove anybody he wants to remove through emergency situation in the country.
Suspended, suspended. I guess you meant to say suspend rather than remove. And by the way, the Supreme Court ruled, did give a verdict on that, saying that this has to be for a certain period. It cannot be prolonged.
Kingsley, I will use the adjective suspended. But during that suspension, a period has been suspended, will it be acting? Will it be in office? So if you want me to use suspension, I will use that suspension. In fact, I will not be surprised if tomorrow the president decided to remove a governor not suspended now in the name of emergency rule, and the Supreme Court will support it. I'm not surprised. I'm surprised with this judgment. I want to align myself with the judgment of the dissenting judgments. I think that for me, with due respect, that should be the position. While the president has the power to declare state of emergency, that power does not extend to the removal of suspension or removal of an elected officer. When they said it must be for a specific time, so who will now determine the time now? Where is it stated in our law that the president can do that? But it must be for a specific time. Where did they get that one? Why did they import? Where did they import that into the law? There was nowhere in that law which says so. Recently, the president declared a state of emergency in the country. Why did he not suspend himself from office in the name of emergency? So as far as I'm concerned, if you look at that provision of Section 305, the emergency they are talking about has to do with security. So once there's insecurity in the country, what the president do is to do what he is doing now in terms of declaring state of emergency, in trying to look for extraordinary means to solve the problem. Extraordinary means here means including deployment of soldiers who are not supposed to be deployed in a civil matter, the suspension of a fundamental right. That can be done. But to say the president who has the power to suspend elected governor, for me, Kingsley Kai, I think it's overboard as far as I'm concerned. The Supreme Court has gone overboard in that regard. We do respect.
Tunji, the Supreme Court did mention too that while making that judgment, that verdict, while giving that verdict, did mention to the fact that the law and that Section 305 does not expressly state in what condition the president has the powers to declare the state of emergency. Do you think that there should be some tweaking, there should be some amendment to the law to make things clearly stated, so that this will not be interpreted in any way vaguely going forward? We know that there's a precedent by the Supreme Court already given today. So do you think that there should be clear cuts terms stated there in what condition the president has the powers to declare the state of emergency?
Kingsley, if we truly want to save our democracy and we truly want to check the president, the exercise of the president, with this judgment now, there's a need to immediately amend the Constitution to clearly state the extent of the power of the president. The Supreme Court said there was nowhere in the Constitution where it is stated that the president has no power to suspend a governor. Was there anywhere in that Constitution where it is stated that the president can suspend a governor? Why did they pick one and leave the other one? Why did they also look at that area where it did not? Because there's nothing in that Section 305 which states that the president has the power to suspend the elected officer. So if they are saying because there is no provision in that law which empowers which restricts the president from removing suspending a governor or elected officer, then there's also no provision in the law which empowers the president to do so. So for me, as far as I'm concerned, it's a dangerous precedent. I want to repeat, dangerous precedent, and this is more like giving the power, the more unfettered power to the president to become authoritarian, to become more to have more authority to do as he likes. Because you see, when you give this kind of power to the president, that would be a threat to the governors. You can see some of the governors who are running extra when the president does not even possess the power clearly. Now that he has a clear authority to determine whatever he can do, that can be because people were afraid that when there was local government crisis in Osun State, the Osun State government was concerned, and that was why I was running to Aso Rock or to Body Lom or whatever to meet the president to discuss, thinking that they were, because they were worried at that time that the president may also say there's crisis in their state and therefore they want to declare state of emergency. So with this power now that the Supreme Court has given to the president, he has handed over all the states or all the elected officers to be under the president. In fact, as it is now, he can even suspend a senator, not only the governor. He can suspend senator, he can suspend House of Rep member, he can suspend a councillor anywhere that was elected just like the president. As far as I'm concerned, I think the Supreme Court will do respect in their own. I agree with them in their own wisdom. That's what they think is law. But like I said, I want to align with the dissenting judgment because I see that as more protecting our democracy than what the other people, the majority, said.
Now, you said, and we do know that when the Supreme Court makes the verdict, it is final. There won't be no tweaking on that. I think there are very few times, correct me if I'm wrong, when the Supreme Court has, reversed itself. But given this verdict today by the Supreme Court, what maybe legal, maybe political safeguards exists, or would you recommend to prevent an abuse of emergency powers by the executive arm of government, by the presidency, whether this incumbent president, whether presidents to come in the future? Because, I mean, beyond President Bola Tinubu, it could be another president tomorrow who decides that, so this state is maybe an opposition state and decides, okay, little chaos, let's declare a state of emergency there. Anybody could use this as a tool. So what frameworks, what safeguards do we need to put in place to prevent an abuse?
Christy, I said it earlier, but let me first of all say, look, when I said when the Supreme Court give judgment, you cannot appeal it. The fact that tomorrow the Supreme Court will make a decision that is different from this one does not mean they sit appeal. That's not appeal. That's a review of the case, or maybe probably because they see otherwise from what they saw in this case. Probably they may change it. So changing it does not mean they sit on appeal. That's not appeal. That's a fresh decision on a different matter. They will not come back to this case. They will not, this matter between the Attorney General and the PDP governance will not be the one to where they will now come and say we are changing it. No. If another case may happen tomorrow and then they want to say we want to challenge it. They can change their mind and say, look, we saw a different position here, and therefore we are changing our mind that the president cannot do that. It can be done. That's not an appeal. Kingsley, I said it earlier on that if you want to protect our democracy, this is the time the National Assembly or anybody, a bill should be passed to make it clear the extent of the power of the president when it comes to emergency. So if a law is made today stating clearly the extent of the power of the president, these Supreme Court judgments which say the president has unfettered power to do and undo when it comes to emergency will no longer apply. That regulation, that law, will now be the one to govern the state of emergency procedure. So if you are truly interested in our country, if you are truly interested in democracy, I think the National Assembly should look into this line. They should be able to do. But unfortunately, I'm afraid that we don't have a National Assembly who will do that. In fact, Kingsley, I'm more afraid that the way we are going, this is how some of these African countries create a C-type president. Because when the president believes that he can get anything done, and he will want to try his luck. And with this National Assembly that we have, and with this kind of judgment coming from the Supreme Court, Kingsley, I'm afraid that if the president wants to try his luck, he may get it.
By trying his luck, you mean, by trying his luck, what do you mean?
To be a C-type president, to continue. They can amend the constitution, and the court will say yes, they have the power to amend in that regard to extend. Very
much doubt that with the level of Nigeria's democracy, we can go in that direction.
Which level of the democracy? This democracy where our court is saying that the president has the power to remove an elected officer. This democracy where the National Assembly will be thinking about a mandate to stand. This democracy where the national anthem at every function now is our mandate. Which democracy are you talking about?
Well,
We like to deceive ourselves.
While you know, not taking anything away from what you have said, I was referring more to the political consciousness amongst Nigerians, not elected officials necessarily.
Political consciousness. If anybody tells me that the Supreme Court will say what they say today, I will say no. I will say it's very clear. Initially, they said they have no jurisdiction. They have no local standing. Sorry, there's no cause of action. Why did they look at the case of? They said there's no cause of. In fact, there are two grounds now upon which the case was thrown out. One, that there's no cause of action. Two, they said let's even look at the case itself. They said that the president has the power. They affirm the authority of the president. This is what I expect when they decide the case of Labour Party and PDP. When they did say that it's an internal affair, I expect them to also go further and look at the matter on the merits and give judgment. They didn't do that. So I was expecting them to say, look, there is no cause of action, therefore the case is struck out. I do not expect them to go further, bearing in mind what they have been doing before now. Because they want to confirm, because they want to clearly confirm the authority of the president and give the president that power, they will have to go to the merits and look at it. Unfortunately, I am disappointed. I won't lie to you. With due respect to the Supreme Court, I am disappointed because this now a democracy is wrong. We are giving the president please borrow my adjective. The president now has unfettered power to do as he likes. He can wake up tomorrow and what little dispute between NLTW and one other person in the state. In fact, even dispute between 1-2 people, which result into them chasing themselves, can be termed as emergency, and the governor will be removed, will be suspended, and it will be in line with the law as it is today, because there's authority. Supreme Court said it that he has the power. So how can you in a democracy? By
the way, Tunji, you know, the Supreme Court's used of a prolonged term, you know, the term prolonged term. Don't you think that is vague too? Because, I mean, one might consider, and that president or even the incumbent president might think that, 6 months is not enough to resolve the so-called political crisis, so let's make it 12 months. You know, let's make it 18 months.
Where did they see the that the president should exercise the power? Where is the number? Do they even? I was expecting them to also fix a time when the president will do that. How long did he do it? How many minutes? How many days? Because there's nothing. There's nowhere in the constitution where that is. In fact, the constitution did not envisage this situation where a president will suspend the elected officer. That was why it's not there. It's not an omission in the constitution. It is not an omission. If you look at that section clearly, section 305, the issue there is about security. And
but the river situation was clearly about security. It was about the security of lives and property of the river's people, wasn't it?
Which life and property? Let's even assume that I don't want to go to that area again. Let's even admit that there's crisis in that state. Is it the crisis? Is it the removal of the governor that will stop it? Are you saying the governor or suspend of the governor? Are you saying the governor is the one fueling the crisis? Even if the governor is fueling the crisis, is it suspect? When they say state of emergency in the section 305, it has to do, if you look at all the issues about security and what the government president is doing now in the country by declaring the state of emergency has been declared on security in the country today. Is that not so? Did you see the president suspend himself? Did you see him suspend himself? That's danger. Why did you not say, I hereby suspend myself from office because there is insecurity and we have declared an emergency? So if you can declare an emergency in the River State and suspend the governor, now that we have declared a state of emergency in the country, the president should also suspend himself.
All right.
And continue. So, okay. like I said, I am more bothered about the fact that we don't have anybody to rescue us now. The judiciary that should serve as a check on the and prevent the excesses of the executive, and the National Assembly should also do the same thing. In alignment, they are in alignment with the president and with the executive. They are home and ground with the executive. They are like one working together.
All right.
Because whatever the president is doing now, whatever he has done, the National Assembly and the president will confirm it. You can see the National Assembly when they were supposed to ratify the what's it called? The state of emergency, when the law clearly stated that it must be by 2/3 majority or something like that or whatever, other than they can't do an head count, they did their first votes. I would not be surprised if by tomorrow somebody go to court and the Supreme Court will tell us, yes, first votes can determine total majority. I won't be surprised. They come and tell us that, look, once you hear everybody shout, that means they've all agreed. I won't be surprised.
Tunji,
you see, this we are not in the. That's why I continue to say it. I was at a particular section yesterday in my state, and I was telling them that, look, when they ask me about democracy, I think there's no democracy in Nigeria. What you have is civilian rule. There is no democracy. And this is not democracy. In democracy, there must be separation of power. The executive is in place, the legislative is in place, and the judiciary are in place to check themselves. The executive has the power to check the judiciary. The judiciary and they also have the power to check the executive. Then what do we see today? In the name of collaboration, in the name of working together, we see them doing things together as one. Then when they say collaboration or whatever, what they are saying is that you must make sure you work for the progress of the country. They are not saying you should be in bed with the executive. That's not the fact that you ask questions from the executive, or the fact that you are asking or querying what the executive is doing, does not mean you are fighting them. Does not mean you are on the progress. You are doing the right thing, and that's why today you see us incurring a lot of debts, because National Assembly will not even ask questions before approving any debts. So for me, I am sad that it appears that now a state where there is nobody to check anybody, particularly the executive, where the judiciary that we should rely on as the last hope of the common man is now in tune with the executive.
Okay.
Where the National Assembly, for the people who should be asking questions on behalf of the people, are now singing on the mandate of the executive. It's sad, Kingsley.
No, your tone, as a legal practitioner, is one that is quite worrisome, considering too that Nigerians who are not legal practitioners but follow different legal, political related developments in the country they've complained over time about judgment verdicts from the courts, whether Supreme, whether High, whether magistrate courts. They've complained about the judiciary in general in time past. Do you think that this verdict today by the Supreme Court may further erode the confidence that Nigerians have in the judiciary?
Kingsley, I in fact, with sadness, I agree that it may further erode the confidence in the judiciary. Kingsley, I'm not happy saying what I'm saying. I'm not happy criticizing the judgment of the Supreme Court. I'm not happy. But you see, if we want a country that will move forward, and I want the development of our country, we must tell ourselves the truth. If you want to pretend and then say we should just because I will one day apply for to be an SAN and somebody will come and block me because I've said something before or this and that, we'll not move forward, Kingsley. I am not speaking because of my selfish interest. If not, I'll just keep quiet. I'll just be following them. I'll just keep tapping for them. In the name of in the future, I may want to be an SAN or apply for anything at the Supreme Court, and therefore they will say, we have looked at the future and we realize that you are all criticizing us. But I'm speaking because I'm a concerned Nigerian, not about myself, about the future of the country. We need to do the right thing if we want a country that if we want our country to move forward. Simply, today is a sad day for me as far as I'm concerned. This judgment has dampened my morale. In fact, the little morale that I have, that we may likely have hope, it's being eroded, Kingsley. It's being eroded. I'm telling you, Kingsley, I am so sad that today we are handling the country. Not only this president. Another president is coming, and he has a president already. So I'm not complaining because it has to do with President Bola Tinubu. I'm looking at the future. That we have a president that doesn't care, that wants to just run everybody over, or he wants to become a sit-at president. He has a plan already. All right. Let's wrap. We should have people who stand for the democracy that we are saying we are practicing.
Let's wrap the conversation.
Defense of the people.
Yeah, let's wrap the conversation real quick. Then talk about Nigeria's federal structure. This is what this conversation really is about: the autonomy of state government in times of crisis. With this judgment of the Supreme Court, I know you said something. You said quite a few already about this, in line with this. But in closing, What does this do about the autonomy of state governments? Do they still have, autonomy, and autonomy in times of crisis?
No, even before now, they don't have that. When it comes to managing security in the country, before now, they don't even have that autonomy. They don't have it because they are just a chief security officer on paper. Because the commander-in-chief of armed forces is the president, and the president is the only person that can direct how the military and the police will operate, or how they will be deployed to anywhere they want to be deployed. Without the authority of the president or the IGP, who is under the supervision of the president, sometimes if he doesn't want to answer to any governor, they cannot control him. He has a choice. He has a discretion to either answer the call of a governor or not to answer. That's not autonomy. So if they have autonomy regarding security in their state, then the chief security officer, as the chief security officer of the state, he should have the power to control whoever that heads security in the state. Currently, we have a sad situation in our country. Our country is digging deep down the floor. We are instead of moving forward, we are going down. It's a sad story for me today that this kind of is coming from the Supreme Court.
Do you just looking back now, real quick as we go, do you think that the president could have declared the state of emergency if this was Lagos? Okay, I'll take that back. So it doesn't look like a direct attack on Lagos because the president is directly connected to Lagos. But if this was the state where the state governor was elected under the All Progressives Congress, do you think this could have happened in that state? The president could have declared the state of emergency?
If it is where?
Yes, if Rivers State, where this was declared at the time when the governor in Rivers State was, still with the People's Democratic Party. I'm saying if this was a state, if Rivers State at the time was controlled by the All Progressives Congress,
it was not about the fact that the president was the governor was in PDP at that time. It was because the minister of FCC as the heirs of the president at the time, and they want to favor the minister of FCT at that time. They want to align with his position. They want to return the control of the state into his hand because it appeared he was slipping away from his hand to somewhere else, and they want to bring it back. So I cannot say whether this is that. It's about political interest. If the political interest align with the president at that time, whether you are in APC or PDP or whatever, it may happen. So it's not about political party. It's not about the person involved. It's about the interest of the president. If it's aligned, the way I see it now, it's about interest. You will recall that it was the FCC minister that first informed us that the state of emergency will be lifted, and it was lifted. And he even said that if you want the state of emergency to continue, it will have continued. So it shows that it's not about the party, it's not about the whatever. It's about interest of individuals. So once individual has an interest and they want to protect it, they can be assisted. So as it is now, I tell you, some of the governors, some of them will even be afraid now to do anything against the government. In fact, I will not be surprised if most of the government now say we are on your mandate to standing the president, because for the fear of the president can declare emergency in my country. And we know, and I know the kind of country that we have. To start crisis is not difficult. What they call crisis in Rivers State was not even there at all. What happened in some states like Kwara State and Zamfara and other places where people have been killed? Was that not enough to declare state of emergency if we are talking about truly state of emergency or crisis? What happened in Rivers State? There was just a bomb blast, which we were told thereafter there was something like that. That was just a mere normal occurrence in that area. And unfortunately, there was no any need for state of emergency at that time in Rivers State, as far as I'm concerned.
Tunji,
they want to use it, and the Supreme Court has even given the president more power that could do to the Supreme Court.
I'd like to thank you so much, barrister and solicitor of the Supreme Court of Nigeria, for being a part of the conversation to discuss this very important matter regarding Nigeria's democracy. Indeed, we've been discussing the Supreme Court's verdict on emergency rule in the country, that which was taken by President Bola Tinubu back in the month of March when he declared the state of emergency in Rivers State, suspending further beyond the declaration of that emergency. He suspended the governor, his deputy, as well as state lawmakers there, and appointed a sole administrator who took charge for 6 months. Well, we've gone past that now. The Governor Sim Fuba, has since moved to the All Progressives Congress, as Tunji referenced, on the president's mandate. He stands now. Well, we'll continue to monitor developments. We'll see how things go from here. Will there be another state emergency declaration now that the Supreme Court has set this precedent, giving the president even further wings to fly in that direction if he so chooses? Well, we'll see what happens. But again, Tunji, many thanks for joining me today.
Thank you for having me, Kingsley. If you are not in the good book of the president, don't allow any crisis in your state. Otherwise, you can go by way of suspension. The Supreme Court has affirmed it.
You have to drop that there. You have to drop that there. I'll take that as the final shot, your final thought. Okay, that's the show today. Many thanks for being a part of Homo Politicus today. Kingsley Bass is my name. Stop by the comment section. Let me know what you think of this verdict of the Supreme Court. Of course, it was 6-1, and well, the same way it did split the Supreme Court in some way. I'm sure that this judgment will split a lot of Nigerians along party lines, along political alignments, along maybe, hopefully not, tribal and religious line, hopefully not. But yes, politically, maybe that's foreseeable. But yes, that's the show today. Many thanks. Until next time, we say may God continue to bless the Federal Republic of Nigeria. Bye for now.